The Institute.
Institute for Justice.
The National Law Firm for Liberty.
Hello and welcome to Short Circuit, your podcast on the Federal Courts of Appeal. I'm your host, John Ross, joined this week by IJ litigators Paul Sherman and Diana Simpson. This week on the show, Flashbang grenades, Docs v. Glocks, and DC's event poster ordinance. Diana, kick us off.
So the 11th Circuit has a case this week about flashbang grenades, and a woman there was asleep at 5:30 in the morning in her boyfriend's apartment and woke up with a flashbang grenade landing on her leg. So for those of you unfamiliar with flashbang grenades, they are incendiary devices that make noise and make light in an effort to disorient folks as part of a SWAT team entering a house, usually.
Although I think that understates it a little bit. Like they make noise of like 170 decibels, which is louder than being near a jet plane taking off.
And quite a bit of heat, too.
Yeah, the opinion says that they get up to 2,000 degrees Celsius.
Which is twice as hot as lava. So the reason that they were using the flashbang grenade in the first place was because they had obtained a warrant to search a gentleman's apartment. The application for the warrant had said that a confidential informant had observed a small quantity of a green leafy substance suspected to be marijuana in the defendant's possession. And the defendant had several arrests for possession of marijuana, he had sold narcotics from his apartment, and he was known to carry a handgun. So the application authorized a no-knock provision for the raid.
So a no-knock warrant is essentially when the SWAT team comes in and instead of like knocking and waiting for you to come to the door, as they would do with the normal execution of a warrant, they bust down the door, the SWAT team runs in, and they arrest you. And the ostensible purpose of this is that they either don't want the destruction of evidence, they don't want to give the person in the house time to flush drugs down the toilet, or they think the person is dangerous and they want to disorient and confuse them. And this has, frankly, become a very standard procedure in serving warrants on people who are suspected of possession of even small amounts of marijuana.
So in this case, allegedly, a flashbang grenade went in a window and landed on the bed.
Yes, so it landed on the girlfriend's leg, and she ended up spending 3 days in the hospital with pretty substantial burns. But so for the no-knock provision, they had an operational plan. The SWAT team had set this up, and it was the plan through which they were going to raid this home. And the operational plan called for the use of 2 flashbang devices, basically outside of the house and on the outside. And but it vested the officers with the authority to use more flashbangs if they needed to. And so one of the officers used a flashbang under this, extra authority provision, and that particular flashbang is the one that caused the injuries to the girlfriend and is at issue here.
One of the distressing things about this opinion, but the facts described in this opinion, but unfortunately is all too common, is that the plaintiff in this case alleges that she was burned because a flashbang was thrown and landed in the bedroom next to her and burned her. And there was evidence in the case that indicated that there was evidence of an explosion within the bedroom. But the police officer who threw the flashbang testified under oath that the flashbang detonated outside the house. We don't know who's telling the truth, but the facts certainly seem to indicate that the plaintiff's argument here is a lot better than the cop's argument. And again, this is something that we see in a lot of these qualified immunity cases.
I mean, how can you even make that claim with a straight face? You've got a woman with burns, the bed sheets are burned, and yet the officer's saying, oh, no, I threw it outside the window.
I frankly think that police officers are used to courts deferring to them. This is something we see in a lot of these qualified immunity cases. And, unfortunately, this case is sort of a mixed bag because what ends up happening is the court finds that this was excessive force, that it violated this woman's constitutional rights. And they don't believe the officer's story. They credit the woman's story. But they also hold, unfortunately, that the right to not have a flashbang thrown into a room that the cops haven't surveyed yet was not clearly established at the time. And so as a result, future people who are subject to this kind of injury, they can recover monetary damages, but this woman's out of luck.
So it is now clearly established in the 11th Circuit, in addition to the 6th, 7th, and 9th Circuits, as the court pointed out. Unfortunately, how many people have to be injured in the other circuits that haven't addressed this issue until it is clearly established throughout the country?
Okay, let's move on to the next case, which also comes out of the 11th Circuit. Paul?
So this case is an oldie but a goodie. Popularly, the case is known as Docks versus Glocks. There have been 3 previous panel opinions in this case, and now we finally, after like a year and a half, have an en banc decision. So we're excited to finally be able to talk about this case. The case concerns a 2011 Florida law which prohibited physicians from making routine inquiries of their patients whether they owned firearms. There's some other provisions, too, that talk about you can't harass patients on the basis of whether they own firearms. You can't discriminate against patients on the basis of whether they own firearms. But basically what all of this was aimed at was a proposal by the American Medical Association that said that physicians should routinely inquire into whether patients own guns. That way they can give information to patients about gun safety. This upset some people in Florida. It upset gun rights activists, and it results in this law, which promptly gets challenged on First Amendment grounds.
Diana, this is a 90-page opinion. Can you give us some of the highlights?
Yeah, so the court strikes down 3 of the 4 challenged provisions. And the reason that this case is such a big deal is that it applies the First Amendment in a broad way to professional speech. And it doesn't seem broad to those of us who actually litigate under the First Amendment, but a recurring problem is that courts seem to denigrate speech that's offered in a professional setting, in an occupational setting. And the court here says, well, that's ridiculous, and the First Amendment applies, and the government didn't offer any evidence. They can't do that. And the court really walks through why the First Amendment is important here and why the law can't withstand that.
Yeah, what we're really seeing here is this tension between 2 strains of constitutional doctrine. On the one hand, over the past 40 years, the Supreme Court has said that First Amendment rights, even outside of traditional areas of political speech, are very, very highly protected, and courts should scrutinize burdens on those rights very closely. On the other hand, as listeners of this podcast know, when it comes to things like economic liberty, the right to earn an honest living, the regulation of professions, courts don't scrutinize those kinds of restrictions very closely. So what is a court supposed to do when you have a regulation of speech that is occurring within a professional context? And what historically courts have basically done is thrown up their hands and deferred to the government. But the court doesn't do that here. It recognizes that physicians have a First Amendment right to make these inquiries of their patients, to talk to patients about the subject if they want to. And if patients don't like that, they have the right to find another doctor. That's, I think, exactly the right First Amendment outcome. So this is a good decision. It doesn't go quite as far as I would like it to go. I think that the best reading of the Supreme Court's case law is that these kinds of restrictions should be reviewed with strict scrutiny, which is the highest standard of judicial scrutiny. The court doesn't resolve that in this case. It says that it doesn't need to because it thinks that these burdens fail even a lower level of scrutiny, a type of intermediate scrutiny.
There's several concurrences in this case as well, Diana. Can you talk about those?
Yeah, so Judge Wilson wrote a separate concurrence, and Judge Wilson was a member of the original panel in the case, and so he submitted 3 separate dissents in each of the original 3 panel decisions, basically saying, no, really, the First Amendment applies. No, really, the First Amendment applies. And this time he was able to submit a concurrence saying, I told you that the First Amendment applies, and here I'll go even further than the majority and say that this court should reach the same result by applying strict scrutiny as indicated by the Supreme Court's precedents. And so Judge Wilson's concurrence is great. It goes through a lot of the big issues with the level of review to apply to one of these ordinances. Judge Pryor wrote a separate concurrence talking about how the Second Amendment is a really cool thing, but that this case is not about the Second Amendment. And then Judge Marcus wrote a separate concurrence underscoring really the main en banc court's decision. There was a single dissent by Judge Joe Flatt. He did not agree at all with the majority opinion, and so he wrote a single and lone dissent.
I mean, one of the things that concerns me about Judge Choflat's dissent is it's clear that he just doesn't agree. And he's very open about this. This is not like reading the tea leaves. He's just very open about the fact that he doesn't agree with the direction the U.S. Supreme Court has gone. And he more or less openly calls for lower courts to defy that precedent, find ways to get around it, until such time as it can be reversed. The thing that he cites the most throughout his opinion is the work of Justice Breyer in dissent in a recent case called Reed versus Town of Gilbert. I find that a little troubling. I was also a little bit troubled, even though he reaches the right result, with Judge Wilson's concurrence, where he argues for strict scrutiny, because one of the lines that he draws that I think doctrinally is not correct is that he suggests that the decision to license the speaker in the first place, that does not get any First Amendment review. But once someone is licensed, once someone is a physician, then there's limits on how you can regulate them. But that would suggest that if you are not licensed by the state, the government has a free hand to regulate your speech. And that's something that we've actually encountered in some of our litigation here, where the government has said, if you want to give dietary advice, you have to be a licensed dietitian. And, our argument to that, which has been successful, is that no, everyone has the right to give dietary advice. Everybody talks about diet. Under Judge Wilson's concurrence, I think it would be a different outcome. It would say that we can prohibit people from giving dietary advice until they're licensed, but once they're licensed, we can't regulate the content of their dietary advice. I don't think that's the right First Amendment outcome, but luckily that's not what the en banc court did today.
Okay, and with that, we'll move to our final case, which comes out of the D.C. Circuit. Diana?
Right. So as Paul was just talking about with the Docks v. Glocks case, Judge Joe Flatt in dissent talked about a case called Reed v. Town of Gilbert, and Judge Joe Flatt disagrees with that case and perhaps may have encouraged other courts to basically disregard the Supreme Court's ruling in that case. I think that is a good segue into the lamppost sign regulation involved in this D.C. Circuit case. So the District of Columbia has a regulation that dictates how people can post signs on lampposts in the district. And here, the relevant regulation allows people to post signs and keep them up for 180 days. But if a sign is related to a particular event, it must be removed within 30 days after that event. So theoretically, an event-based sign has fewer than 180 days that it can go up. And so this particular case has been in litigation since about 2008, and the sign code has been amended a few times in the pendency of this litigation. But against this backdrop, these folks filed a complaint alleging that they wanted to just have signs up, and they wanted to have them up for longer than the D.C. regulations allow, and went back and forth between the district court and the Court of Appeals a couple of times. And on this version on this particular appeal to the D.C. Circuit, the court has to address Reed v. Town of Gilbert, which is a case that has just come down from the Supreme Court within the past couple of years, talking about sign code regulation in the United States.
And it's difficult to overstate the importance of Reed versus Town of Gilbert. It is one of the most significant First Amendment decisions, certainly of the last 20 years. What Reed stands for, or what Reed helps to clarify, is this notion in First Amendment law called content-based regulation of speech. For when a law is content-based, it means that it regulates speech on the basis of its content, on the basis of what it communicates. And what the Supreme Court has traditionally said is that those kinds of regulations are subject to the most stringent kind of First Amendment scrutiny. But for about 20 years, there has been this confusion in the doctrine about how do you tell if a law is really content-based. And what some courts have said is what you do is you just read the law, and if the law defines the regulated speech by what it says, that's a content-based regulation of speech. That's a very straightforward approach. What other courts have said is, no, we look to what the government's motivation was in regulating the speech. And if they were regulating because of disagreement with the content, then that's a content-based regulation. What Reed says is that it's both. Either of those is sufficient to determine that something is content-based and therefore gets the highest level of First Amendment scrutiny. So in this case, what you would think would happen is that the law says if a sign is related to an event, it's regulated differently than signs that are not related to events. How do you tell if a sign's related to an event? You read it. So that would suggest that it's a content-based regulation.
And yet that's not the result the D.C. Circuit came to.
That is not the result that the D.C. Circuit came to. The D.C. Circuit determined that the regulation was not content-based because it did not distinguish between different types of event signs. So because all event signs were treated with the same brush and had to be removed within the set number of days after the event, that it is not content-based, so it is subject to a lower level of scrutiny. I don't think that this flies with Reed v. Town of Gilbert. Reed says that any regulation that singles out a specific subject matter for differential treatment, it is content-based, even if that regulation does not target viewpoints separately. I don't think that those two rulings can withstand each other, but that's what the D.C. Circuit did.
Yeah, I mean, it seems like kind of a backdoor way of going back to the test that existed before the Reed decision came down. But it's not totally without foundation in Reed versus Town of Gilbert, just not the majority in Reed versus Town of Gilbert. There's a concurrence in the Reed decision written by Justice Alito, which is cited extensively in this decision by the D.C. Circuit. And that concurrence reached the same conclusion, but it included this list of signs that Justice Alito and a couple other justices thought would not be content-based. And they refer to things like signs that discriminate between on-premises and off-premises advertising. That's really difficult to square with the majority of Reed, which Justice Alito and these other justices joined.
Yeah, and so, that's what's great about Reed is that it's this big sea change of First Amendment litigation and of sign code regulation specifically. But as this case demonstrates, even a very clear explication of a rule in Reed won't end sign code litigation throughout the country.
Okay, that concludes the show. Thanks for listening. We appreciate you. Until next time, this is John Ross from the Institute for Justice, wheedling you to get engaged.